Hi, I'm Tony Joe. I've been a realtor in Victoria, British Columbia for more than 25 years. I'm joining you today from the British Columbia Real Estate Association's offices in downtown Vancouver. BCREA is the voice of BC's realtors, providing advocacy, ongoing education, economics analysis, and standard legal forms. Today, we're here for the third in a series of conversations on cannabis, a web series brought to you by BCREA to help consumers, realtors, and other real estate professionals get a better understanding of the risks of growing cannabis at home. I'm joined today by Michael Litchfield to talk about cannabis as it relates to disclosure and growing cannabis. Michael, tell us a little bit about yourself.
Great. Well, my name is Michael Litchfield. I'm a lawyer, and I'm the managing director of an educational consulting company called ThinkLab. I also teach at the University of Victoria.
Great. Well, thanks for joining us, Michael.
Thank you for having me.
So, Michael, when you first learned about the legislation to legalize cannabis, what were your first reactions as a lawyer?
Well, one of intense interest, actually. So anytime there's new change in legislation, it opens up new areas of practice. So in regards to the cannabis legislation in real estate, it really has opened up new questions for rental licensees, strata licensees, and trading services licensees.
So let's talk about defects. Can you describe the differences between a patent defect, a latent defect, and a stigma?
So a patent defect is something that can be discovered on reasonable inquiry or reasonable investigation. And this would be something that negatively impacts the home or the property. So if we use an example of a roof, for instance, if, for instance, there are some roofing tiles that have fallen away, maybe some water's gotten inside the home, and you can clearly see that with a simple investigation, that would be an example of a patent defect. Mm-hmm. A latent defect, if we use our roofing example, would occur where perhaps the membrane wasn't laid properly and there was some damage going on underneath the tiles, but you wouldn't be able to see it without actually ripping those tiles up. Yeah. So that would be a latent defect. Stigma is something different altogether, and stigma does not have an actual legal definition, but it's widely understood that a stigma occurs where an individual buyer has a subjective feeling about some attribute of the house that negatively impacts their decision.
Yeah. So an example, for instance?
So an example with a stigma would be if somebody passed away recently in the home. Yeah. That may be bothersome to some certain individuals. Yeah, absolutely. Or some kind of paranormal activity, absolutely.
Okay, so now in the context of what we're talking about today, which is cannabis, from a patent, latent, and stigma standpoint, what could they look like?
So if, for instance, somebody was growing marijuana in a home and there were moisture issues and black mold occurred on a wall that you could clearly see, that would be an example of a patent defect. Yeah. A latent defect, if we use the same example, would be if mold grew inside the drywall. So in order to get to that mold, you'd have to actually destroy the drywall or remove the drywall. That would
not a simple investigation.
Exactly. Yeah. So it goes beyond that reasonable inquiry or investigation. And then a stigma could be if there was an illegal grow operation and a specific buyer didn't want to purchase that property because of the...
Because it was used that way.
Exactly, yeah, exactly.
So Michael, with the new legislation, what should a buyer be concerned about before fully committing to their purchase?
Yeah, so a buyer of real estate in British Columbia needs to be aware that, subject to certain exceptions, the doctrine of caveat emptor applies. And caveat emptor really means buyer beware. So again, subject to the certain exceptions, a buyer must do their own due diligence to discover whether there is anything negative about the property that may impact their purchasing decision. So from a cannabis perspective, if a buyer is concerned if cannabis has been grown in the home,
illegal or not,
yeah. They may want to do their own due diligence to discover whether that has been the case or not, including asking the agent for the seller whether they're aware of the growing of cannabis in the property.
So they must do their own homework.
They do have to do their own homework, absolutely.
So how should a realtor approach a conversation on stigmas related to cannabis with their seller?
So I think the heart of that conversation has to be about education. So the role of the realtor is to educate their seller client on their obligations and the obligations of the buyer. So when we're looking at a patent defect, the realtor should inform the seller that the buyer has an obligation to perform reasonable investigations to discover any patent defects or hire somebody like a home inspector to do so. When it comes to latent defects, the realtor should inform their seller client that they have a strong obligation to disclose any latent defects that they happen to be aware of. And then in regards to stigma, the realtor should inform their client that they need to answer any questions truthfully. So if a buyer has a specific issue or a specific problem that may negatively impact their purchasing decision, if they ask a question about it, the answer has to be truthful.
Now, how would a realtor approach the conversation on stigmas for a buyer, for instance?
So at its heart, I think it would be the same kind of conversation, educational in nature. The buyer client needs to be made aware of their obligation to discover patent defects. So if they're not going to be examining the property themselves, they need to be hiring somebody like a home inspector to do so. The buyer also needs to be aware of the obligation of the seller to disclose any latent defects.
Because the seller must.
Because the seller must do that, yes, and there's a strong obligation there. And then finally, and importantly, the buyer needs to be made aware that if they have any specific issues in regards to the purchase of a property that may negatively impact their decision, that those questions should be put to the seller or their realtor.
Yeah, so for instance, if a buyer has cultural matters where a stigma might negatively affect them and they might choose not to buy a property, it's best to find out now, right?
Absolutely, and asking that question is key because it puts the obligation on the seller to answer in a truthful manner.
So really good idea for a buyer's agent to make sure they know their buyer.
Absolutely.
Got it. So how does buyer beware apply to the purchase of real estate in British Columbia, specifically around cannabis?
It's really important that anybody involved in a real estate transaction in British Columbia is aware of the doctrine of caveat emptor, or let the buyer beware. This doctrine, subject to certain exceptions, applies to the purchase and sale of real estate in British Columbia. The exceptions to this doctrine are fraud on behalf of the seller, any kind of negligent misrepresentation on behalf of the seller, or a failure to disclose any latent material defects that may exist.
Which they're required to do.
Which they are required to do by law.
Yeah, buyer beware.
Absolutely.
So we've been talking about latent defects, and of course licensees are used to the term material latent defects. So what's the difference?
So often these two terms are used interchangeably, but the important thing to note is that the Real Estate Council rules specifically define material latent defect, and they define it in a way that is slightly different from the way it's been defined in common law. So in common law, latent defect or material latent defect is often defined in such a way that goes to the heart of either habitability or safety of a property. And if a defect does rise to the level of affecting safety or habitability, it will be considered a material latent defect. The Real Estate Council rule that addresses this, however, defines it in a more broad manner. So it includes that concept of habitability and safety, but it also brings in other concepts such as the expense to fix the problem as well.
Interesting. So is growing cannabis inside or outside considered a patent or latent defect or a stigma?
Yeah, so the growing of the cannabis itself is unlikely to be considered either a patent or a latent defect. However, the results of growing the cannabis could cause a patent or a latent defect. So for example, if the growing of cannabis causes moisture issues which lead to mold, if those mold issues are visible on reasonable inspection, that could be a patent defect. If it creates mold issues on the inside of a wall, that could be a latent defect. So it's not the growing itself, it's the possible damage that it may be doing to the home that could rise to the level of a patent or latent defect. Okay. In regards to stigma, the growing itself could be considered a stigma because that could be based on the subjective opinions of the potential buyer. So if a buyer was specifically concerned about the growing of cannabis, that could rise to the level of a stigma.
So like air quality, for instance?
Exactly. Yeah. Any kind of personal feeling that a potential buyer has that may negatively impact their purchasing decision.
Yeah, and that could be a stigma.
Exactly.
So Michael, let's talk about a couple of different scenarios here. So the first one would be in the case where there was a grow-op, a not legal grow-op, but it was fully remediated. What are the risks that a seller is taking in terms of disclosing or not disclosing?
Absolutely. So this is a challenging question, and it really comes down to the concept of remediation. History in British Columbia has shown that grow operations, specifically illegal grow operations, tend to cause significant damage to a home. And so the question is, can it actually be fully remediated? Unfortunately, there's no provincial standard in regards to remediation for grow ops. And so what may occur is a homeowner may feel that there's been proper remediation, operation, if they don't disclose that because they feel it's no longer a defect, there is a risk that they were aware that it was used as an illegal grow operation, and if future damage is discovered, that they could be held liable for that.
Well, so very interesting. So a seller might feel that it's being remediated, but you as a lawyer would question under what standard?
Exactly, and being that there is no provincial standard, I think the concept of remediation is a dangerous concept at the moment. So any realtor who finds himself in this situation, I think, would be wise to take some counsel from perhaps their managing broker, or do some research, or perhaps even speak to a lawyer in this situation.
Yes, but what I'm hearing from you anyways is that seller should be disclosing.
Absolutely. Personally, I would lean towards disclosure. It's a safer option for the seller and for the realtor as well.
Okay, so second scenario, because we're talking about two scenarios. So the second one is if somebody is growing 4 plants or less, so legally, so not causing any damage to the house. Will they need to disclose when they're selling?
Again, this could be a challenging issue to deal with. I would say generally if they are growing their amount of plants that is legal, and if there's no damage that's occurred to the home, then there's no obligation for disclosure because it has not created a patent or a latent defect. Now, the issue may arise if a particular purchaser is concerned about cannabis being grown and they ask the question. It could rise to the level of a stigma in that circumstance. But again, much like our last scenario, these are complex situations, and I would exercise caution for any realtor who finds himself in this situation.
Yeah, and licensees should always be trying their best to make sure that the consumer discloses.
Absolutely. So non-disclosure in these cases creates a significant amount of risk.
So what are risks for homeowners who are considering legally growing cannabis?
So the main risk is that the growing of cannabis may cause damage to your home. As we've discussed, if that damage is visible, then it could be a patent defect. If there's damage that may not be visible but you're aware of it, then that would become a material latent defect, and you would have an obligation to disclose that. Now, the impact of that could be a difficulty in selling your home. It could be possibly having to lower the sale price of your home. So there are very real considerations to think about.
What could be some consequences if a seller chooses not to disclose cannabis in their home?
Absolutely. So there could be a number of consequences. So generally, this takes us back to our concept of caveat emptor, buyer beware. Generally speaking, a buyer has the obligation to do their proper due diligence. However, this is altered in a few situations. The first is our latent defect. So if the seller is aware of a material latent defect, then they have an obligation to disclose that.
They must.
Yeah, they must. Yeah. And to the extent that they don't, they can be held liable for that.
To the point where if the seller says to the licensee, "Don't tell anyone about this," the licensee actually has to walk away from that transaction.
Exactly. So the council rules require the licensee to walk away from the transaction if their client instructs them to not disclose.
Yes.
So it really also depends on how that failure to disclose occurs. So if, for instance, they just fail to disclose, it's never discovered until after the closing, then there could be a legal action against them for failure to disclose that latent defect, and they could be liable for any losses that are incurred. If there's a specific question that is asked of the seller and it's answered in a less than truthful way, that could it could be a negligent misrepresentation.
Yeah. So there could be significant financial ramifications.
Absolutely. So there is a relatively recent case in British Columbia where the damages were in excess of $80,000 for a similar case.
Okay. So how does growing cannabis within the legal limit relate to latent defects?
Yeah, so it's unlikely that the growing of cannabis under the legal limit is going to be considered a latent defect. What can happen, however, is that the conditions of growing cannabis, even if it's legal, can cause damage to your property. And that damage could be considered a latent defect that would require disclosure.
So we're talking humidity, for instance.
Right, humidity is probably the most common example with the growing of cannabis. And if that causes mold issues or other issues within the home that the seller is aware of, then they will have an obligation, a strong obligation to disclose that.
So we're all aware of the licensee's requirement to disclose latent defects that the Real Estate Council requires. How about the case where a licensee maybe doesn't want to know things and instead they take on the position of hear no evil, see no evil.
I would say that that position has some considerable risk to it. And that's because there are additional rules that require the realtor to act and carry out their role with reasonable care and skill. And there actually have been some recent cases in regards to cannabis grow operations where licensees have not done their proper due diligence and have been disciplined for essentially taking that approach. So I would say that that approach comes with some considerable risk.
Yeah, so not a good idea to stick your head in the sand and hope that everything's okay.
Exactly. I think it's a risky position for a realtor to take.
So what would happen if a seller instructed their licensee not to disclose a known latent defect?
So the council rules are very clear on this point. Rule 513 states that if a seller instructs a licensee not to disclose a known material latent defect, then the licensee must remove themselves from that transaction.
Just that easy.
Absolutely.
So Michael, where can viewers turn to for more resources about risks related to both cannabis cultivation and disclosure?
So I would think there's two main resources that all realtors in British Columbia should be aware of. The first is the Real Estate Council, specifically being aware of the rules that relate to material latent defects and that relate to the obligations of realtors for reasonable care and skill in the carrying out of their duties. The second main resource is the BC Real Estate Association. There's a variety of legally speaking articles that address this topic. In addition, this topic is addressed in some detail in the 2019 legal update.
Great. Thanks for joining us, Michael.
Thank you for having me.
And thanks for joining us on this episode of Conversations on Cannabis.